like the idea of parliamentary democracy, or of racial equality, or Marxian political theory, or the idea of science and technology, the very concept of human rights have been gaining momentum throughout the world. It is gaining momentum throughout the world because as and when the civilization develops and the culture of a state along with this individual grows, naturally the protection of human rights is a concern for every one of us. The elimination of wars and the restoration of peace will have no meaning in a society if human rights are not protected. And hence, the protection of human rights is considered an area of relevance today. You might be knowing that the French Revolution broke out on three important grounds: liberty, equality, and fraternity. And the very concept of liberty, equality, and fraternity from the time of the French Revolution has been gaining ground all through for all times. And after the French Revolution, you might be knowing again, the American Revolution or the American War of Independence, those spoke and believed and enforced the same rights and won independence for the state of America, and it became United States of America. Thereafter, in the state of the United Kingdom, lots of rights were protected. And this is through the Industrial Revolution of the state of England. And in the meanwhile, between the 17th and 19th century, there were a few rights which were recognized, were accepted and enforced by the international community. One right happened to be the Convention on Slavery and Slave Trade. Slavery and slave trade has been practiced throughout the world, and especially it was common in the African region. Somehow this had to be put to an end, and the state of Great Britain took great measures in the year 1807 to prohibit the practice of slavery and slave trade in her colonies. Later, the conventions were adopted, and once the convention was adopted, naturally the states who are parties to the convention are bound to adopt its provisions. The other important right happened to be the protection of minorities. In the Eastern Europe and the Eastern European part, there were several European states. And these states, remember, were full of minorities. You take the instance of the state of Poland, take the state of Austria, take the state of Russia, or you take Latvia, Lithuania, and many other countries in this region. For the first time, after the Pact of 1856, they felt, the members of the international community or members of these states thought that it should be protected come what may. And hence, between East European states, there are at least 22 treaties were signed. And most of these 22 treaties were bilateral treaties. Under these bilateral treaties, minorities were protected. Now, when we speak about the minorities, one section of the people in a society should not be treated as unequals. And this kind of discrimination cannot be tolerated by any society. That was the message that was given. Now, minorities, when we speak about it today, they enjoy essentially 3 to 4 basic rights. One is the right to promote their language, wherever they are, wherever they are situated. The right to have education institutions. The right to have religious and charitable institutions. And the right to religion. And the right to get funds from the consolidated fund of a particular government where they are placed. Now, these are the rights that were being spoken. With all said and done, you might be knowing, the Second World War broke out. And when the Second World War broke out, remember, for the atrocities which are committed, perpetrated during the course of the war, the international community thought of adopting to humanize war. War has to be humanized. As Hendrik Wallon, in his book on mankind, the story of mankind, he just points out War cannot be avoided, but then war like gunpowder only destroys, it cannot build. When war cannot build and only results in destruction and devastation, it has to be humanized. And the Geneva Convention of 1949 on the humanitarian loss of war came into force thereafter. And the Geneva Convention of 1949 only speaks about what we call as what rights the prisoners of war enjoy. What rights the people who are in a battle, in a ship, they enjoy. And in the event of capture, how prisoners of war are to be treated. What exactly are the role of the Red Cross in the event of a war, and how they are supposed to assist the victims of war. Now, with all this said and done, when the Charter of the United Nations came in, the Charter in its preamble spoke about the basic human rights. The Charter of the United Nations in its preamble pointed out, we the peoples of the United Nations, twice in our generation suffered from the scourge of war. And from now on, at least, the state should be in a position to treat everyone with dignity and respect. That is why the Charter spoke about the equal rights of men and women, of nations large and small. And everyone is entitled to the promotion and protection of basic human rights in their territory. And having spoken in the preamble, Article 1, Paragraph 3 of the Charter of the United Nations said, discrimination based on race, discrimination based on sex, discrimination based on religion, and discrimination based on language is absolutely prohibited. That is the message that was conveyed in Article 1, Paragraph 3. Then afterwards, in Article 55 of the Charter of the United Nations, it spoke about the basic protection of human rights. And in Article 56, it went to the extent of pointing out states are supposed to take joint and separate action for the enforcement of these rights. So the states are given a mandate to see that joint and separate action are to be adopted by the state for the enforcement of these rights, which are mentioned in paragraph 1, 3, and 55 of the Charter of the United Nations. Then when we go further, the Charter of the United Nations came in. And after the commencement of the Charter of the United Nations, you might be knowing, lots of developments were taking place. And some of the states have expressed a concern. The Charter of the United Nations speaks of human rights. And it says discrimination based on sex, race, religion, and language is prohibited. But then we need, what we call as in clear terms, a definition of rights. What rights are allowed to be protected? And how these rights are liable to be enforced by the parties who are states, essentially. Now, with respect to what has happened was the General Assembly authorized its members through the Human Rights Commission and other bodies to draft what we call as a Universal Declaration. The very name of the Universal Declaration points out it is applicable to all states. And it is applicable to all peoples of the world. Please don't be under the impression that is applicable only to the states. Remember, without applying to individuals, it is just a myth. And nobody will believe in it. What is being adopted by the United Nations ultimately are made applicable to the peoples of the world. And the people should be in a position to derive these benefits which are enshrined under the Universal Declaration of Human Rights. Now, the Universal Declaration of Human Rights was ready, and this was placed before the General Assembly of the United Nations on 1948, December 10th. Now, the president of the committee happened to be Mrs. Roosevelt. Now, Mrs. Roosevelt, when she submitted before the General Assembly of the United Nations, pointed out the Universal Declaration is the Magna Carta of all mankind. It is the Magna Carta of all mankind because there are certain basic rights which are being spoken under the Universal Declaration of Human Rights. These rights are to be respected by everyone and every state. Now, what exactly was the content of this message? The content of this message is very simple, because in the United Nations today, you have what we call as the Latin American bloc. You have the European bloc, and then you have the East European bloc. Then thereafter, you have what we call as the African bloc. Then you have the Asian bloc. Now, these blocks, remember, naturally belong to different sects, different kinds of civilizations and different cultures. And to make the protection of human rights applicable to all the 5 regions of the world, the European region, the African region, the Latin American region, and the South Asian and what we call as the Southeast Asia region, they wanted to have a content on human rights. So this content on human rights is applicable to all people, to all states. That is what it speaks about, the spirit of the Charter of the United Nations. So it was adopted, and when it was adopted, many people said that this is the greatest achievement of man. And the Universal Declaration of Human Rights contained 30 articles. And you will be interested to know what exactly these 30 articles are all about. Now, when I speak about the 30 articles, first 21 articles make a reference to civil and political rights. So 1 to 21 naturally speak about civil and political rights. Article 22 to Article 27, they naturally make a reference to the economic, social, and cultural rights. Now, when we make about what we call as the civil rights, civil as well as the political rights enshrined in the Universal Declaration. Remember, I shall just tell you and explain to you what these rights are. The first one which is envisaged or provided in Article 2 of the Universal Declaration is everyone is entitled to all the rights and freedoms set forth in this declaration. That means what? After Article 2, there are several rights which are being mentioned. And these rights which are mentioned here are to be enjoyed by everyone wherever he be, irrespective of nationality, irrespective of creed, irrespective of language, irrespective of race, he is entitled to enjoy without distinction of any kind, such as race, color, sex, or language. Now, thereafter, the Article 3 speaks about everyone has the right to life, liberty, and security of the person. You might be knowing again, Article 21 of the Constitution naturally speaks about the right to life. If Article 21 of the Constitution has made a reference to the right to life, now here is the inspiration. Article 3 of the Universal Declaration makes a reference, everyone has the right to life, liberty, and security of the person. Thereafterwards, you may be Article 4 of the Universal Declaration points out that no one shall be held in slavery and servitude. So slavery as an institution was condemned, as I just mentioned to you in the beginning. So the Universal Declaration, for the first time, gave a befitting reply saying that the institution of slavery and slave trade could be put an end. You may be knowing the dictum of 10 Commandments. Man is born free, but everywhere he is in chains. Death is better than bondage. Though slavery and the selling of slaves, buying of slaves, and practice of slave trade in all forms is forbidden by the Universal Declaration under Article 4. And if you look to the International Covenant on Civil and Political Rights, Article 8 of the Civil Rights Covenant prohibits the practice of slavery and slave trade. Now, under Article 5 of the Universal Declaration of Human Rights, no one shall be subjected to torture. What is important is treating everyone with dignity is the most fundamental thing that has to be practiced by everyone, by every state. So in situations like this, you cannot torture a person. Degrading treatment cannot be given. And such punishments is totally prohibited as per the provisions of Article 5 of the Universal Declaration. Now, Article 6 of the Universal Declaration points out everyone has the right to recognition everywhere as a person before the law. We say individual is the end of all laws. But for the individual, your laws, your what we call as the approach which is being done by the administration, the administration is not going to serve anyone. It is without any utility. And everything is done by a government or done by a state or done by the United Nations or done by specialized agencies are for the welfare of the individual. That is the message that is being conveyed. Now, Article 7 of the Charter of the United Nations points out all are equal before the law and are entitled without any discrimination to equal protection of the law. Now look to Article 14 of the Indian Constitution of India. Now when we speak about the Constitution of India under Article 14, it ensures the right to equality. Right to equality without discrimination of any kind. And inspiration is in Article 7 of the Universal Declaration of Human Rights. And not only that, equal protection. And when you give protection, that cannot be the type of practice that was prevalent before the French Revolution or the American Revolution. You treat the super class of the nobility as under a separate legal law or a separate laws which are made by the state. That is not allowed to be done. Then under Article 8 of the Universal Declaration of Human Rights, everyone has the right to an effective remedy by the competent national tribunals. So in the event your rights are snatched, your rights are taken away by the government or by the administration, you should have some avenue to get a remedy. You should be permitted or allowed to go to the court of law and seek remedy. This is the most important thing which is being accepted and practiced and believed and enforced in the court of in the legal system. Then Article 9, no one shall be subjected to arbitrary arrest. Think of this, think of our November procedural laws as well as the constitutional law. No one shall be subjected to arbitrary arrest, detention, or exile. Before arrest is made, he should be given the grounds of his arrest. For what purpose he is going to be arrested? What exactly are the reasons behind his arrest? It should be informed, and then only such decisions can be materialized. Then we go to Article 11 of the Universal Declaration of Human Rights. Article 11 points out everyone charged with a penal offense has the right to be presumed innocent. You know, under the Constitution, no one is guilty unless he is, remember, a convict declared by the court of law. Every person is innocent unless he is a declared convict by the competent court of a particular country. That is being spoken in Article 11 of the Universal Declaration. Now, thereafterwards in Article 12, no one shall be subjected to arbitrary interference with his privacy, family life. This is Article 12. No one shall be subjected to arbitrary interference with his family and privacy. So you can't just, or a person can't just interfere with the private life of a particular person. Each person is sovereign and independent and is not dependent on someone to lead his life. In situations of this kind, you can't just interfere in the personal life or the personal life of a man or a woman. That is the message that is being conveyed. Article 13 of the Universal Declaration points out everyone has the right to leave his country. Suppose, for example, it points out everyone has the right to freedom of movement. If it has the right to freedom of movement, it permits him the right to leave any country, including his own, and to return back to his country. Now, right to return back to his country, again, is a fundamental right. Take it this way, tomorrow you intend to leave and go out of the country. Nobody can stop you. And from anywhere. And you intend after time to come back to the country, nobody can stop it. This is permitted under the law. Under Article 14 of the Universal Declaration, everyone has the right to seek and enjoy in other countries asylum. Asylum, remember, is a human right today. Suppose the very concept of asylum originated because if a leader of a political party, if he is under threat, and the threat is given by the ruling party which is in power, at that time, he is empowered to go to a country where protection is being given. So, a political criminal or a religious criminal or a military personnel cannot be extradited for the sake of trial. It is being a right. Because if he returns or if he is brought back to his country, his life will be in danger. So, asylum is a right under international law, and this is expressed under Article 14 of the Universal Declaration of Human Rights. Then the other one, under Article 15 of the Universal Declaration of Human Rights, everyone has the right to a nationality. Suppose, for example, Mr. X takes his birth in India. The moment he takes his birth in India under the jus soli principles, he acquires the nationality of the state of India, that is the place of birth. And suppose, for example, the place of birth, this is jus soli principle. Under the jus sanguinis principle, the nationality of the parents of birth nationality becomes the nationality of the child. Suppose you, husband and wife, go to the state of the United States, and during the stay in the state of the United States, a child is born, and the child is entitled to get the nationality of the state of the United States. Simultaneously, it retains the nationality of the state of India because the nationality of the parents are the nationality of the state of India. This is the reason that is being given. Now, thereafter, under Article 16 of the Universal Declaration, men and women of full age without any limitation due to race, nationality, or religion have the right to marry and found a family. So if you are a human being and if you come of age as prescribed by the government, you are entitled to marry. Not only you are entitled to marry, but you are entitled to found a family in the event of children born to your family. This is essentially a right. That is why Universal Declaration is known as one of the finest declarations which are adopted for mankind. Then thereafter, under Article 17 of the Universal Declaration of Human Rights, everyone has the right to own property. Everyone has the right to own property, and either for himself or in association with others. Everyone under 18 of the Universal Declaration, everyone has the right to freedom of thought, conscience, and expression, right to religion, right to movement, right to freedom of thought. Remember, freedom from arbitrary arrest, all of them are being spoken. Now, freedom of opinion and expression is being conveyed in Article 19 of the Universal Declaration. Now, thereafter, under Article 20, everyone has the right to freedom of peaceful assembly. Suppose, for example, you have some program, and in this program, in order to materialize, you intend to have a freedom of assembly wherein you intend to convey the message, this is what we are going to do. So this is a right, freedom of assembly. And then no one may be compelled to belong to an association. Suppose, for example, you have several trade union activities, and the trade union members' executive office cannot compel a particular person to belong to a particular trade union. That is not allowed to be done. Now then we come to what we call as Article 22. See, the rights which are, I spoke thus far, happen to be civil and political rights. Now comes economic, social, and cultural rights. Now, everyone as a member of society has the right to social security. See, you might be knowing the labor laws which are enacted by a government. Under the labor laws which are enacted by a government, remember there is what we call as a right to social security. He is entitled to get a pension at the time of retirement. or he is entitled to get some kind of bonus at the time of retirement. So this is what we call as social security. When a person completes his office tenure and retires, he should be having served certain amount or regularly some kind of payment to be made for his maintenance by the government. This is called as social security and is entitled to realization through national effort and international cooperation and in accordance with the organization and resources of each state, some economic and social cultural rights. Then everyone has the right to work, a basic right. Students of labor law, especially you will be studying labor law, you should be in a position to understand this. Everyone has the right to work, to free choice of employment, to just and favorable conditions of work. Then everyone has the right to equal pay for equal work. Think of Article 39 of the Constitution of the State of India. What we call as the equal pay for equal work. Legislation was passed by the government of India in the year 1979 itself. Then everyone has the right to form and join trade unions. This is a basic right that is being accepted under the law. If you are a laborer, you have the right to join trade union. And you have the right to collective bargaining. And if the employer is not giving you a satisfactory salary, naturally, you have the right to wage agitation against the employer. And under Article 24, everyone has the right to rest and leisure. A particular employee, a particular worker cannot be made to work more than 8 hours a day. Now, these are some of the rights which are mentioned in the Universal Declaration in articles one by one. Under Article 25, everyone has the right to a standard of living, adequate for the health and well-being of himself. The most important right. During the Corona period, this right was spoken and championed in several forums. What does it say? Everyone has the right to a standard of living, adequate for the health and well-being of himself and for his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security in the event of unemployment or sickness. Because during the COVID period, most of the people were thrown out of employment. And at that time, they were actually demanding, remember, some kind of help or some kind of social security from the government. That is where the government of India ordered free rationing for almost 8 months, 9 months. Then again, it renewed it. This is to take care of the citizens and the duty of taking care of them rests with the government. Then thereafterwards, everyone has the right to education. You may be knowing, which is being part of today, Article 21 of the Constitution through an amendment. Right to education is a fundamental right that cannot be stopped. He can go to a school of his choice and pursue the education. Education shall be free. We know it. Education shall be free, at least in the elementary and fundamental stages. Then Article 27, everyone has the right to freely participate in the cultural life of the country, of the community. If you belong to a particular community, and if the community organizes certain functions exclusively for them, or in national festivals, this is a right which is being recognized by the Universal Declaration of Human Rights. Then everyone is entitled to social and international order in which the rights and freedoms set forth in this declaration can be fully realized. Now, these are a few of the rights which are being spoken under the Universal Declaration of Human Rights. Now, when we speak about the Universal Declaration of Human Rights, there were several commentators. They point out that it is only a declaration. Since it is a declaration, it is not binding and it has no legal effect. This is Harsh Lauterpact, one of the champions of the protection and promotion of human rights, and who was a Royal Professor of International Law at the University of Cambridge, and later became a judge in the International Court of Justice, was the first to write a book on human rights in the year 1948. Soon after, the Universal Declaration of adopted, that is within 5 months, he wrote the book. wherein he was simply saying the charter obligations of human rights are binding. But then the human rights, Universal Declaration of Human Rights, remember, has no legal effect. But then one should know that it is adopted under the Charter of United Nations. And to see that the Charter principles are, remember, given a good publicity, and all the states belonging to all the regions accept these rights in their practice. That is why the Charter of the United Nations came in for the promotion and protection of human rights. Now, when we go further, many of the scholars in the area of international law, when they comment on the Universal Declaration of Human Rights, they point out that the Universal Declaration of Human Rights is a common standards of achievement for all peoples and all nations. I have just said it in a different way. Now I am using the language which is being given by them. It is a common standard of achievement for all peoples and all nations. So everyone is supposed to follow these principles that are enshrined under the Universal Declaration of Human Rights. Then the Universal Declaration of Human Rights further represent the spirit of the Charter of the United Nations. This is said by another great writer. It represents the spirit of the Charter of the United Nations. Because what is indicated in Article 1, Paragraph 3 and Article 55 is put forth by a declaration containing of almost 28 articles, although 30 articles are there in the Universal Convention. Now, another aspect that one should remember is it sets out legislative programs in municipal and international law. Now, some were criticizing, it is only a declaration. But then, during the course of debate that has taken place in the General Assembly, before its adoption, members of the international community and their representatives have clearly indicated that the Universal Declaration sets out a legislative program. It is not enough if the Charter speaks about it. When once the Universal Declaration is adopted, naturally all nations are supposed to adopt legislative measures for purpose of implementing the rights which are recognized under the Universal Declaration. Now, when they speak about it, this is the minimum that is being issued. And if they want to confer extra rights and other things, they are most welcome. Nobody is going to harm them. Nobody is going to question them. But the minimum for all states of all regions under the United Nations is the Universal Declaration of Human Rights. That is why it is the spirit. And from here, you get the inspiration. And the inspiration which is derived from here should enable you to enact or to adopt a law in your domestic sphere so that the people of your country or your region feel happy and enjoy these human rights. Now, you might be knowing when the Universal Declaration was moved and adopted by the General Assembly of the United Nations, it was adopted with a voice vote. At that time, there were 58 states, and the 58 states who were present in the General Assembly accepted it unanimously. That is why it represents the authoritative, it is an authoritative document adopted under the Charter of the United Nations. Professor Louis B. Sohn, one of the scholars from the University of Harvard, he points out the Universal Declaration of Human Rights is an authoritative interpretation of the Charter. Remember, it is an authoritative interpretation of the Charter because they wanted to give which are the rights that are essential for a common man in a country. And the government of the day should be in a position to give these rights to him. And this is always, remember, goals and commitments to be realized by states. And it is the duty of the states. The goals are being spoken, protection of human rights are spoken under the Charter of the United Nations. And the commitments are to be made by the states. Because the states have voluntarily, without any force, without the use of force, nor without the use of any coercion, have become members of the United Nations. They have become members of the United Nations by ratifying the Charter of the United Nations. So they have accepted what we call as the goals which are enshrined under the Charter. Thereafter, remember, when the Universal Declaration of Human Rights are adopted, they have to make a commitment for the enforcement of the recognition of these rights in their domestic sphere. Unless they make a commitment for the adoption of these rights in the domestic sphere, it will be of no use. Then these 58 members, when the matter was moved, without dissent, they said, yes, we need this. Our people should benefit these rights. That is why it is Universal Declaration of Human Rights. Now, having said this much, I just wanted to speak to you what exactly are the response of states. Now, in the General Assembly itself, I can just tell you, many states, the representative states made wonderful speeches. And these speeches are available if you go to the United Nations documents from the United Nations Library, you will be in a position to get the statements which are being made. As I just said, it was called as the Magna Carta of all mankind. Quincy Wright went to the extent of pointing out under Article 56 of the Charter, states are bound to take joint and separate action. They said joint and separate action for the protection and promotion of the rights which are mentioned in the Charter, as well as the Universal Declaration of Human Rights. Then the state of Haiti's representative at the United Nations went to the extent of declaring it is one of the most authoritative declarations adopted by the United Nations. And in the Tehran Declaration, which was adopted in 1968, the declaration went to the extent of pointing out the influence of the Universal Declaration is equivalent to the Declaration of the Rights of Man of 1776. That far they have gone. Now, we just want to know what exactly the effect of the Universal Declaration. Now, the Universal Declaration was adopted in all the rights you have come to know, and I have just made a mention of this. Now, there were several declarations were adopted by the General Assembly of the United Nations. And in these declarations, there was a reference to the influence of the Universal Declaration. In the preamble to these declarations, they make a reference to being influenced by the Universal Declaration, we adopt the following declaration. Now, which are they and what exactly are their contribution? One declaration was adopted in the year 1960. And this declaration happened to be the granting of independence to colonial countries. So, in the declaration on granting of independence to colonial countries adopted by the United Nations General Assembly in 1960, it referred to the Universal Declaration of Human Rights. Being influenced by the Universal Declaration of Human Rights, we have to adopt this. That is the way it was. The influence of the Universal Declaration went there. Now, when I speak about the granting of independence to colonial countries, he said all the states which are colonies should become free. The colonial masters should leave their country, and they should facilitate for self-determination and independence for the colonies. Now, the second declaration happened to be, it was in 1963. Now, in the year 1963, there was a declaration on the elimination of racial discrimination. And in the declaration on elimination of racial discrimination, in the preamble, they went to the extent of citing the impact of the Universal Declaration. Being influenced by the Universal Declaration of Human Rights, we hereby adopt. That is how the influence has gone. Now, in the year 1963, there was another declaration which was adopted by the General Assembly on condemning the practice of apartheid. Apartheid, especially in the state of South Africa, remember, was very common and it was practiced to the hilt in Namibia. And this should be put to an end. And at that time to relay and to put the weightage on the 1963 resolution on apartheid. They quoted the Universal Declaration of Human Rights. Thereafter, remember in the Tehran Declaration, again you find a reference to the Universal Declaration of Human Rights. And you may be knowing the establishment of the Organization of American States. There you find, remember in the preamble, something known as something of the Universal Declaration of Human Rights. There was a conference which was adopted, which met in Caracas in 1954. And this Caracas conference of the American and Latin American states again endorsed their, remember, faith in the Universal Declaration of Human Rights. Now, these are some of the one more Helsinki Declaration was adopted in 1975 in the month of August. In the Helsinki Declaration, again, a reference was made to the Universal Declaration of Human Rights, the preamble to the declaration. Now, if these are the few declarations, there are several conventions that were adopted. In the conventions which are adopted after 1952, after 1950, you find the influence of the Universal Declaration. I just intend to speak to you. One important convention happened to be the Convention of the European Convention of Human Rights. European Convention of Human Rights was adopted in the year 1950. In the preamble to the convention, it goes to the extent of pointing out and mentioning the impact of the Universal Declaration on the European Convention. It simply states, being influenced by the Universal Declaration, we hereby adopt to implement the provisions of this Convention on Human Rights of 1950 of Europe. Then we come to what we call as the other important conventions relating to the establishment of the organization of the African Charter of Human Rights, which is called the Banjul Charter of Human Rights. The Banjul Charter of Human Rights, which was adopted in 1981, again makes a reference to the Universal Declaration of Human Rights. Now, prior to that, you may be knowing two important conventions were adopted by the international community. And these conventions, one covenant happened to be International Covenant on Civil and Political Rights. The second one happened to be International Covenant on Civil, Political, and Civil, Cultural, Economic, Social, and Cultural Rights. In the Civil and Political Rights Convention, as well as in the Economic, Social, and Cultural Rights Convention, there is a reference to the Universal Declaration being impacted or influenced by the Universal Declaration of Human Rights. Now, moreover, you may be knowing self-determination was considered as a human right in these two conventions. Then thereafterwards, you have plenty of other organizations which came in. For example, in the Association of Africa and Non-Aligned Countries. In their meetings and several resolutions, they have quoted the Universal Declaration of Human Rights. Now, when I make a reference to this, one naturally comes to know the statistics that was being taken. In the first 19 years of the adoption of the Universal Declaration, remember that is between 19 years, means 1948 to plus 19. In the first 19 years of the adoption of the Universal Declaration, the Universal Declaration has been quoted 75 times. It has been quoted 75 times in important conventions or declarations or resolutions which are adopted by the General Assembly of the United Nations. That virtually speaks about the influence of the Universal Declaration in the formative period. That is where now the great scholar from Harvard, he pointed out it is nothing but the authoritative interpretation of the Charter of the United Nations. Then we go to discuss something relating to the influence of the Universal Declaration in municipal courts. What we call is whether the municipal courts were influenced by the Universal Declaration. Now, Universal Declaration came in 1948. After its adoption, there were several cases came before the Now, first I take into consideration the state of the United States, American courts and the application of Universal Declaration of Human Rights. Then I will make a reference to the state of India. Now, when we take into consideration the American courts, there came a beautiful case before the Supreme Court of the United States. And the name of the case is Oyama versus California. And Oyama versus California happened to be a case which was decided in the year 1948. Now, in this case, what has happened was, there were several Japanese nationals who had gone to the state of California. And having gone there, they have acquired nationality of the state of the United States and residing in California. Thereafter, they established their family. And once they established their family, children were born to them. And once children are born to these people, Japanese parents, they acquired certain property in the name of their children. And at that time, a Californian law which was enacted by the state of California nullified this, saying that for the children of foreign parents, although they are nationals of the state of the United States, are not entitled to own property. But at this juncture, the parents were not in a position to tolerate this, because under Article 17 of the Universal Declaration of Human Rights, it permits everyone to we call as right to property. Then when the matter went to the United States Supreme Court, there were four judges. I shall mention the names of 2 or 3. One happened to be Justice Douglas. The second one happened to be Justice Murphy. And the third one happened to be the Justice Rutledge. Now, Justice Murphy went to the extent of finding out the very alien land law which was enacted by the government of California is violative of Article 14, the 14th Amendment to the Constitution, not Article, 14th Amendment to the Constitution of the State of the United States, where everyone is entitled to certain basic rights. And it is indicated in the 14th Amendment, and that cannot be denied, it has to be conferred. Then another judge, Murphy, went to the extent of finding out we have become a party to the Charter of the United Nations. And the Charter of the United Nations is a multilateral treaty. And the state of the United States has undertaken obligations of the provisions of the Charter. The Charter speaks about the basic rights. Discrimination based on religion, place, sex of birth, and language cannot be done. And on this ground, he said he passed the legislation. But there was another judge, that is Rutledge, he also conferred the same opinion. Now, thereafter, what has happened was another case came up. And this is called as C. Fuji versus California. And in C. Fuji versus California, this is a case which was decided in 1953. Now, in this case, what has happened was the contents were the same. So, alien parents who are foreigners are not supposed to acquire property in the state of California in the name of their children. Now, here, the judge was very harsh. He went to the extent of finding out if this were to be adopted by the state of the United States, when it has become a party to the Universal Declaration of Human Rights, as well as the Charter of the United Nations. Remember, the very spirit of the Charter principles will die. Then he quoted in another paragraph, Article 17 of the Charter of the Universal Declaration simply points out everyone is entitled to own property. And can this be denied? And it is one of the basic rights which are guaranteed and assured under the Universal Declaration of Human Rights, and he quashed completely the alien land law. Now then we go to the third case, which is called as Wilson versus Hacker. Now in Wilson versus Hacker, what has happened was, there was a lady who was running the bar. And this lady, to run the bar in the state of New York, United States, had employed several lady servants. and they were working as servers in the bar. One fine morning, she gets a notice. And she gets a notice from the trade union. And the notice says that from now on, you are supposed to employ people who are recommended by the union only. So those people who are recommended by the union only should be employed inside the bar. Now she challenged this order, and having challenged, she goes to the extent of finding out, in the event of accepting what the union is saying, it will defy the provisions of the Universal Declaration of Human Rights. It will violate the provisions of the Universal Declaration of Human Rights for one important reason. So equal rights of men and women will be deprived of. Under these circumstances, the court should restore this and should not be compelled to employ anybody. And the court actually struck down and went to the extent of saying union cannot force these things, and she is empowered to employ people of her choice. And with the result, maid servants were all also allowed to be served without to be appointed in a bar in the state of the United States. Now then came what we call as another important case, Filaretiga Pena versus Irala. This is Filaretiga versus Pena Irala. This was a decision of the United States Supreme Court on torture. And in this case, the Supreme Court of the United States pointed out, remember, torture and the prohibition of torture has become a customary rule of international law. Under no circumstances one can inflict and punish with the torture. And if you do that, it will be nothing but, remember, the concerned state violating the existing rule of customary rule of international law. Now, so for example, there came another beautiful case that came up in the state of Germany. And this actually spoke about Article 12. Article 12 of the Universal Declaration of Human Rights, which was protecting the privacy of a family. And protecting the privacy of a particular family has entered and became part of the state of Germany through Article 8 of the European Convention of Human Rights. Article 12 of the Universal Declaration of Human Rights protects this. And when the European Convention on Human Rights was adopted, this was mentioned in Article, remember, 8. Now, the facts of the case is like this. An alien, having gone to the state of Germany, has married a woman. And remember, there were children born to them. What has happened was an executive order was issued against him and he was expelled from the state of Germany. And at that time, the higher court in the state of Germany pointed out he cannot be expelled for the simple reason under Article 12 of the Universal Declaration of Human Rights, everyone is entitled to the right of privacy. Under no circumstances the state has the right to disturb the married life and the private life of people, and they should be allowed to stay. So this was a major decision which was given by the German court by invoking the Universal Declaration of Human Rights. Then thereafter, remember, there are several cases that came up before the Supreme Court of the State of India. When the cases came up before the Supreme Court of India, I just intend to speak to you. The first case, remember, wherein the human rights provisions of the Universal Declaration came in for questioning. Now, one such decision happened to be Keshwan Bharati versus State of Kerala. In Keshwan Bharati versus State of Kerala, the Supreme Court of India, during the course of the argument, pointed out the Universal Declaration of Human Rights came in 1948. But then we have adopted our constitution on December 26, 1949. All the members of the Constituent Assembly were knowing and following and directly collecting the information about the Universal Declaration of Human Rights and the subsequent developments that were taking place in the area of human rights. Although The Universal Declaration is not a binding document for us. Its principles, its rights, and essential rights, which are part of the Universal Declaration of Human Rights, are part of the Part 3rd of the Constitution of India. Now, when we take into consideration the Part 3rd of the Constitution of India, you just think of what we call as right to equality, then right to equal opportunity, non-discrimination. There cannot be gender discrimination of any type. Protect the gender, you can have, the state can have the laws enacted and enforce it. Then we come to what we call as Article 19 of the Constitution of the State of India, wherein you have what we call as freedom of expression, freedom of thought, freedom of movement, then freedom to religion, all freedom from torture, freedom to dignity. All these rights are part of the Constitution of India. This is what the Keshwan Bharati versus State of Kerala in its judgment pointed out. All the rights which are part of the Universal Declaration are part of the Constitution of India, and most of them are enshrined in Article 19, Article 14, Article 21, right to life, and other rights. Now, when we go further, there were several cases came up before the courts in this country. Now, the first court case that came up in the year 1969. Now, the first case is Magan Bhai Ishwar Bhai Patel, Union of India. Now, in this case, what has happened was, first and foremost, while adopting international conventions, or before a convention come into force in this country, should there be an act of ratification by the government? So, if an international convention were adopted at the United Nations, should there be an act of ratification by the Parliament of the State of India was the question. Now, in the Justice Magan Bhai Ishwar Bhai Patel versus Union of India in 1969, the Supreme Court pointed out, if the rights which are recognized under the International Convention, if they are very similar and if they are justiciable, if they are in accordance with the rights which are mentioned in the International Convention, are not violating any of the domestic laws, then ratification or the act of ratification is not required. If both the rights recognized in the international legal system as well as in the national legal system are similar and not violating, there is no need to have a legislation for the expression. Just go to read the judgment of Magan Bhai Ishwar Bhai Patel versus Union of India and paragraphs 198, 99, and 200. You will get to know. Now, thereafterwards, another case that came up in this country happened to be Jolly George versus Varghese versus Bank of Cochin. In Jolly George Varghese versus Bank of Cochin, the decision of 1969 was replaced, remember, by Justice Krishna. He went to the extent of pointing out, a foreign convention or a convention which is adopted by the United Nations or some other specialized agencies will not come into force in the State of India unless it is ratified by the Parliament. He went to the extent of saying that ratification, act of ratification is very much essential. Without any ratification, remember, it will not come into force. Now, this was relating to the International Covenants on Civil and Political Rights. Whether these conventions are in force without an act of ratification. And he said, no, act of ratification is very much essential. Now, that is why the 1969 decision, when it was reversed, what exactly are the subsequent developments that have taken place is a question before us. Now, immediately after this, there came another case. Valsamma Paul versus University of Cochin. This was a case which came in the year 1996. Now, he was just saying any kind of discrimination is a violation of human rights. Any kind of discrimination, if it is made, is Justice Ramaswamy was the one who or the presiding officer, in his judgment, he pointed out any discrimination, if it is practiced in the area of human rights, it is violation of human rights. And if it is gender-based, then we have to be very strict in enforcing the rights which are recognized under the Constitution as well as in international conventions. What he was saying is, now the Supreme Court or the other court judges in this country can get the inspiration, and if this inspiration can be put into the Constitution of the State of India while interpreting the provisions of human rights. But thereafterwards, you might be knowing again in the year 1996, another case came up, which was Vishaka versus State of Rajasthan. In Vishaka versus State of Rajasthan, the Supreme Court of India very clearly pointed out that the Supreme Court, while interpreting the provisions of the chapter on human rights, can derive inspiration from international conventions or from international documents, provided these instruments or conventions or the rights recognized therein do not violate Article 14 of the Constitution, Article 15 of the Constitution, Article 19 of the Constitution, and Article 21 of the Constitution. So any of the provisions which are mentioned in an international document, and if it is not going to violate the Article 14, 15, 19, and 21, naturally you can incorporate because you derive inspiration from those articles. So then came after this, remember, a beautiful case came up before the Supreme Court of India. This is Geeta Hariharan versus Reserve Bank of India. And this was decided 1995. Now in this case, Justice A.S. Anand and Umesh Banerjee were the important judges who were the presiding officers. Now while deciding the case, they pointed out that domestic courts are under an obligation to give regard to international conventions. So nicely it is being put. I am quoting the judgment. The domestic courts are under an obligation to give regard to an international convention and norms, construing domestic laws when there is no inconsistency between the two. What does it mean? It simply means where there is no inconsistency between the international convention as well as the national convention, the concerned judges or the interpreters of the Constitution are empowered to get much inspiration or to derive inspiration from the international covenants. Now, thereafterwards, we go to discuss another case, Chairman Railway Board and others versus Mrs. Chandrima Das. Chairman Railway Board and others versus Mrs. Chandrima Das, which is a case which was decided in the year 2000. Now, in this case, for the first time, they pointed out the applicability of the Universal Declaration of Human Rights and principles thereof may have to be read, if need be, into the domestic jurisdiction. Now, what he says is the principles thereof, the Declaration of Human Rights and the principles thereof may have to be read, if need be, into the domestic jurisprudence. Into the domestic jurisprudence, and having made this observation, the judge went to the extent of pointing out the court emphatically extended the responsibility of the state to protect human rights even of foreign nationals. So it was in this case that only they referred to the Universal Declaration and the rights issued therein, but went to the extent of guaranteeing certain rights which are basic human rights and going into the protection of human rights of foreigners as well. Now, these are a few of the important decisions which are given by the Supreme Court of India and wherein a mention is made to the Universal Declaration of Human Rights. Now, the last part of the story is, are there any decisions of the International Court of Justice wherein the Universal Declaration of Human Rights is invoked? And if the answer is yes, which are those decisions, which are those judgments wherein the International Court of Justice decisions are just mentioned or invoked? Now, the first decision came in the year asylum. Asylum case happened to be a major decision for the International Court of Justice. In the asylum case, which was decided in 1950, Remember, it was a fight between Colombia as well as Peru. A Peruvian national who was a political leader. Remember, when he was harassed, when he was chased, he goes to enters the state of Colombia. Having gone there, he takes shelter. And when he takes shelter, refuge there, the government of Peru asks for the sake of extradition, for the sake of trial. He should be extradited and he should be punished. At that time, when the matter went before the International Court of Justice, Judge Azevedo, I think he's a Latin American judge, he pointed out the new Universal Declaration of Human Rights should not remain as a dead letter. We should be in a position to enforce the rights. Right to asylum is a right which is guaranteed under the Universal Declaration of Human Rights. If you don't enforce this right, it will remain a dead letter. So a particular person is about to be persecuted. If he escapes to a foreign country, that foreign country is empowered to give asylum. You cannot bring back just because he is your national and try him and execute him. Otherwise, the whole the Universal Declaration and the article loses its charm. That was what the judge pointed out in his judgment. Then came South Africa, West Africa cases. Now, before I speak about the South West Africa cases, I just wanted to tell you the mandate system of the League of Nations was created by the League. You may be knowing under Article 22 of the League of Nations. Remember, certain states were not in a position to govern themselves, were put under the mandate system of the League of Nations created by the League. So the mandate system of the League is created only for those states who are not in a position to govern themselves, or they are weak, or the people are illiterate. Such people or such states will be put together, remember, under a powerful administrative state. And there may be several administrative states. And these administrative states will carry on their activities under the supervision of the League of Nations. The very object is very simple. Entire supervision will take place to see that the people of these territories ultimately become independent, self-sufficient, and will be in a position to govern themselves. So the mandate system created two things. One is the mandatory and the mandated territory. Now, for example, in the Southwest Africa cases, what has happened was Namibia became a mandated territory. It was a poor state. And South Africa was a powerful state run by the whites and supposed to be civilized, which was appointed as the mandatory to look after the welfare of Southwest Africa. And South Africa should see that good governance is given to them. Protection of human rights is given to them. People's voice is heard by the state of South Africa. And it should carry on its activities as per the decisions and the guidelines which are issued by the League of Nations. So 1922 to almost 38, it was submitting under the supervision of the League of Nations. It was submitting its report. Now thereafter, what has happened was it stopped submitting its reports to the United Nations in 1945. So the League died a natural death and the League was replaced by the United Nations. And South Africa went to the extent of finding out the mandate system was created under the League of Nations. And the League, an international organization, has ceased to exist. It has become a different organ. It has finished the course of its life. And there is no obligation on our part to submit to the supervision of the United Nations. But then, when the United Nations came in, they had created what we call as the trust territory and the trusteeship system of the United Nations under chapter 12 of the charter. Now, the trusteeship system of the United Nations, that is chapter 12, speaks about the same mandate system, only the name is changed. So a powerful state will be appointed to look after the territory, which is called as the trust territory. And it is the duty of the trustee to look after the territory so well that human rights are given to them, their voice is heard, and one day they become free country and hoist the flag of independence. South Africa did not do it, and it went on practicing apartheid. So at that time, the General Assembly wanted to know what should be done. And in the General Assembly, they decided the matter to refer to the International Court of Justice. And the matter came before the International Court of Justice in 1950 and pointed out there were 3 questions which were put to the ICJ. First one is whether Chapter 12 of the Charter of the United Nations on Trusteeship System is applicable in the instant case. Then, can South Africa alone modify the system of the mandate system? So South Africa was appointed as a mandatory to look after the territory under the League of Nations. Can South Africa alone alter the status? Then Chapter 12 is applicable or not. Now, for all these questions, the International Court of Justice answered in the positive. First said, Chapter 12, remember, replaces the mandate system of the League of Nations, and hence South Africa should submit to the supervision of the United Nations. Then it said South Africa alone cannot alter the status because there were great powers of time. If there were great powers of time under the Charter of the United Nations, there were people who were responsible, states were responsible in concluding the war. And these powerful states, naturally, you know the 5 members of Security Council. And you cannot alter the status on your own. And hence submit to the jurisdiction, promote human rights, protect human rights, don't show any discrimination of any kind, either on religion or race or sex or religion. All these things were spoken and the matter came to an end. But South Africa went on practicing, remember, apartheid and looting the Namibians. In such situations, the second advisory opinion came before the ICJ in 1962. In the year 1962, remember, the opinion was in favor of South Africa. But then, when the judgment was given, scholars in the area of international law started, remember, criticizing the decision of the International Court of Justice. And in 1970, again, for the third time, the matter was referred to the International Court of Justice. Third time the matter was referred to the International Court of Justice, the International Court pointed out the very presence of South Africa in Namibia is illegal. And it is the duty of South Africa to end its colonialism in all forms and manifestations. On ending colonialism by the South African government, it should facilitate self-determination. And ultimately, sovereignty inside with the people of Namibia. And they only should hoist the flag of independence and not by South Africa. And when I speak of this, remember there was a great judge in the decision. And this judge, remember, J. Ammond, A-M-M-O-U-N-D, he delivered the separate opinion where he pointed out right to equality is one of the essential sacrosanct rights. Right to equality is one of the basic rights, it has to be protected. Here is a case because of the practice of apartheid by the state of South Africa. And the practice of apartheid, the right to equality is taken away. And forget equal opportunity, equality itself is taken away, this has to be restored. And when they spoke about this, they quoted the Universal Declaration of Human Rights. So in the Southwest Africa cases, they went to the court, went to the extent of quoting the Universal Declaration of Human Rights, the judgment itself. Because equality and equal opportunity, all of them are being spoken under the Charter of the United Nations. Now thereafter, remember, there was another case which I just wanted to speak to you, which came under the League of Nations, but has a bearing on the United Nations. And this case happened to be relating to a treaty between the state of Poland on the hand and the free city of Danzig. Now, this is called as the Danzig Railway Officials Case. which was decided by the Permanent Court of International Justice in the year 1928. Danzig, railway officials in the Free City of Danzig enter into an agreement with the state of Poland. And the terms of the treaty is very simple. As per the terms of the treaty, the state of Poland conferred certain special rights and special status to the railway officials in the Free City of Danzig. So they were enjoying the special status in the Free City of Danzig of the special status that is being given to them, and they are only railway employees. Now, what has happened was at a later stage, the entire Danzig Free City merged with the state of Poland. When they merged with the state of Poland, they, especially the Polish government, refused to give these special status and special rights. Now, the railway employees of the Free City of Danzig asked, we have been enjoying these rights under treaty. And when you are enjoying these rights, you are able to confirm. Why you are not restoring it now? Now, the state of Poland bluntly answered by saying that it was an international treaty. And an international treaty gives binding obligation only between states and not between individuals. And this treaty has not become part and parcel of the municipal law or state law of the state of Poland. Since it has not become part and parcel of the municipal law of the state of Poland, we cannot give respect to these rights. Then they went to the extent of pointing out an international agreement will come into force only when the state has ratified it. Since we have not ratified, it is not binding on us. But then the railway officials go to the International Court of Justice. And having gone to the International Court of Justice, they plead before the court saying that this was a right which was conferred to the railway employees under a treaty. Now they are saying it is not possible. The International Court of Justice, having heard the state of Poland, pointed out, look to the object and purpose of the treaty. When you look to the object and purpose of the treaty is to protect. Remember, the employees, the railway employees, and to restore their rights. The very purpose of entering the treaty is you have given certain rights, and these rights are to be honored even now. Now, when it was said, remember, they went to the extent of finding out individual is a subject of international law. From there, remember, the United Nations derived much inspiration. Now, the other important case which I just wanted to speak to you happened to be the Anglo-Iranian oil company case. In the Anglo-Iranian oil company case, I shall just give you in two or three sentences about the facts of the case. Now, certain British nationals had gone to the state of Persia, and they were invited by the state of Persia. And these rich nationals, having gone there, had established what we call as oil refining, oil digging companies. And oil digging companies were established by the British nationals. Afterwards, remember, the kingdom of Persia was replaced by the state of Iran. When the state of Iran came to be established, remember, the state of Iran first nationalized these companies. And when it nationalized these companies, they did not pay anything for these companies by way of compensation. When the companies were not given any compensation by the state of Iran as a successor to the Persian regime, they go to, remember, to the International Court of Justice. And the International Court of Justice gave its decision in 1953. Now, first and foremost, the state of Iran has contended before the International Court, saying that these people have looted us and have living on our blood and made huge money being taken, everything. And with the result, giving compensation does not arise. But then there is an agreement to this effect. And the agreement clearly indicated when they entered there, the agreement, they said in the event of some mishap or nationalization, we will give you compensation. Now, in the judgment, the International Court of Justice pointed out that the Universal Declaration of Human Rights Under Article 17, points out everyone has the right to own property. And if the property is taken away, he is entitled to compensation. So in this case as well, remember, compensation has to be paid. Now, another important case which came up in the International Court of Justice happened to be a Nottingham case. In the Nottingham case, remember, Nottingham happened to be a person born in Germany, living in Liechtenstein, and having lived in Liechtenstein, he changes his nationality and goes to Argentina. Now, having gone there, remember, he wanted to establish nationality. The International Court of Justice pointed out, although there is a right to nationality, there should be the closest and substantial link between the individual as well as his state. Since there is no closest and substantial connection, it cannot be accepted. Now, while delivering the judgment, there was a great judge, Winham, in the Nottingham case, pointed out, Article 15 of the Universal Declaration of Human Rights confers nationality. Under no circumstances, the right to nationality, which is assured and recognized and protected, cannot be taken away by the concerned state. So thereafter, the last case happened to be a case which is called as the United States Diplomatic and Consular Staff in Tehran. In 1979, the United States Embassy was blockaded by the Tehran. So that the Iranian soldiers naturally blockaded the American embassy in Tehran. There were several embassy officials who were American nationals. And these American nationals were not allowed to come out. But at this juncture, the matter goes to, remember, the International Court of Justice. The matter was taken before the International Court of Justice. Remember, the International Court of Justice, the judgment points out, remember, wrongfully deprive human beings of their freedom and subject them to physical constraint in a condition of hardship is in itself meaningfully incompatible with the Charter of the United Nations. So, for human beings, for embassy officials, maybe consular staff, embassy staff, keeping them, remember, under restrictions in itself is a violation of the Charter of the United Nations and the provisions relating to human rights. Now, these are certain things, remember, which speak about the Universal Declaration of Human Rights, its impact on national courts, its impact on Universal Court, International Court of Justice. Now, Universal Declaration of Human Rights is a living document, which will be quoted, which has been quoted, and which is quoted, and which will be quoted even to posterity.